The broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to HDSA's Caregivers Corner webinar series. Today, I am excited to introduce members of the Social Security Administration Office of Disability Programs who will discuss applying for disability with Huntington's disease. Before I invite Art Spencer from the Social Security Administration and his team to begin, I'm going to go over how to ask a question as well as how to access this webinar after broadcast. All questions will be answered following the presentation. However, you can send a question at any time. To send a question, go to the control panel on the right-hand side of your screen, type in your question in the question box, and hit send. This webinar will also be available for viewing approximately 1 week after broadcast on the HDSA National website. To access this presentation, go to www.hdsa.org/ccorner. You'll be able to view a recording of the webinar as well as to download a copy of the presentation. You will also be able to find all of our past presentations, Caregivers Corner presentations. You can find HDSA Lunch and Learn webinars at www.hdsa.org/ll. And now I'm pleased to turn it over to Art Spencer and his team. Art is an SSA veteran. He began his career in 1973 in Virginia working for the Disability Determination Services, which is a state agency that works on SSA claims. Art received a series of promotions and finally was leading the claims office in the Southwest office. Art also led the Delaware Disability Determination Services. Since 2002, Art has been with the Office of Disability Programs in SSA's headquarters. The Office of Disability Programs is SSA's office that focuses on the development and the interpretation of disability policy, the development of tools, training, and data to improve consistency in adjudicating claims, and as well as is in charge of the compassionate allowances designation for expediting the processing of claims involving conditions that are so severe that they obviously meet SSA's definition of disability. And both HD and adult onset HD do qualify for compassionate allowances. So Art is obviously a veteran. I'm so excited to have him, and I'm really pleased to turn it over to him and his team.
Thanks, Jane. I really appreciate it, and thanks to all of you in the HDSA community for being interested in our topics and for hearing what we have to say today. We're going to go through a slide deck that will cover the basics of Social Security Administration disability programs. I'm going to go through this fairly quickly because I know that you're going to have access to it later, and you'll be able to ask additional questions down the road. Our last slide will, in fact, give you a contact person. That'll be Jane for questions after the webinar. And we're doing some technical stuff. Get rid of that block in the middle. There you go. I want to go through this fairly quickly so that there will be plenty of time for questions. So here's the first slide. When people think of Social Security disability programs, sometimes they don't realize that we have two programs. The SSDI program is what you pay into by working. It is can be thought of as an insurance program. If, in fact, you become disabled and can't work, you can draw your disability early. That's the best way to think about it. And you pay for it. The Supplemental Security Income Program began in 1974. The law was passed in 72, but it began processing claims in 74. It replaced the APTD, Aid to Permanent and Total Disability programs in each of the states. And it's very much a needs-based program. Next slide. With Title II, you again, you've paid insurance every time you have a paycheck, and it's based on recency of work and duration of work tests. The best way to guide you is if you need to apply for benefits, the best time to apply is immediately when you no longer can work because of your Huntington's disease. That allows us to make sure that there's no gap in time if we can allow benefits. Again, your monthly disability benefits is calculated in a way very similar to what your retirement would be if you retired at full retirement age, generally 66. And before you get your benefits, you do have to serve a 5-month waiting period. So if we allow you in January of 2013, January, February, March, April, and May would be the waiting period, and you get your first check for June. And you would get your Medicare after being on benefits for 2 years. Next. Title 16, or SSI, is a means-tested program. The numbers shown there are the maximum that you can have as income to be considered eligible for SSI, but there are other programs as well. By the way, you see a lot of links in these slides, and go ahead and just show what that first link looks like. They are active in our program, and you can certainly, well, what are you going to do? But you can go to them for additional information on any of the slides that we need to show. It's okay. Next slide. Thank you. The next bit about Social Security, supplemental security income is that it makes a monthly payment to adults who are 65 or disabled and children, and generally it makes you eligible for Medicaid in your state of residence. I do want to emphasize one thing. The average benefits for SSDI are about $1,100 or $1,200 a month. The average benefits for SSI are about $700 a month. Next slide. The definition of disability, and this is really the meat of this presentation today, it's the same for both programs, and while it's not written here, it is a strict program. To be eligible for Social Security disability insurance benefits, you can't be able to do any work in the national economy. And our definition is keyed on that. So it's the inability to engage in substantial gainful activity. It can best be thought of as work, but there are complicated bureaucratic definitions. The most you can make in a month is this year, $1,040. If you go over that amount, you are considered to be engaging in substantial gainful activity. Secondly, you've got to be unable to work because of a medical impairment or impairments. And of course, that's the first bit. So you have to have approved diagnosis. And this impairment must be expected to result in death, or which has lasted or is expected to last for a period of not less than 12 months. Remember this bottom, the SSA does not pay partial or short-term disability benefits. There are 5 states that do, but they are state programs rather than federal programs. When we get your case, and we've gathered all the evidence available to us, and these are sources of evidence that you have shared with us, the doctors and clinics and hospitals that you go to, we follow a sequential evaluation process to make our decision. First, we ask if you're working. If the answer is yes, we deny benefits. Secondly, we ask, do you have a severe impairment? Does your impairment or combination of impairments significantly limit your ability to do basic activities? If no, we deny your benefits. Third, and this applies most for Huntington's disease, do you meet or medically equal a listing? And the listings describe impairments for 14 body systems. I'm not sure if that link will work. We'll see if it does. If you meet the the listed requirements for Huntington's disease, which is found in 1117. I'm getting ahead of myself right now. It looks like it's popping up. That's great. Yes. So if you go here, you'll be able to wander through and look at all the background material on the listings. But if you meet the requirements precisely, then we find you disabled for benefits. If we have to go to the fourth step, if you are not working, you have a severe impairment but don't meet or equals a listing, then we have to look at work. And we do that by developing a residual functional capacity of what you can do given your medical conditions. And then we decide if you can return to the work you've done in the past or if there's any work in the national economy that you can do. If this is a child's claim, which is an SSI claim for anyone under 18, we look at your case through step 3, and then we also look at something called a functional equals, since of course we don't expect a 12-year-old to have ever worked. Next page. Compassionate allowances. The Compassionate Allowances Initiative, which was developed under Commissioner Astrew's watch, and he was the former commissioner, are lists of conditions that if we can prove the diagnosis, generally will meet our disability standards. CAL conditions receive expedited process, but it's not a separate program. You must still meet the definition of disability to be allowed. So there are some times when you are processed as a CAL condition, but the decision is still a denial. And CAL cases are also evaluated using the same sequential evaluation process. Specific to HD, juvenile onset HD was added as a CAL in August of 12, and adult onset Huntington's disease was added as a CAL on 12 in 12/12. And again, there's a link that can take you to all the CAL conditions and background. And that's okay. We'll just go to the next slide. Now, expedited processing as a CAL depends on the impairment that you as the applicant allege on the disability report when you apply. It's an invisible process. It is a shortcut application, but you won't know you're doing it. It's just we drop out a lot of questions that won't be necessary if we find that you're alleging a CAL condition. So here are some of the words and phrases you might want to use if you're alleging Huntington's disease, so that it flags our computer system to count this as a CAL condition. And again, advanced HD is certainly a good one if that's what you've been told you have. Late stage HD or juvenile Huntington's. Next slide. When you're applying for benefits, you can certainly apply online. Almost everything can be done online. Once you've completed your application, which does take a while, there's a lot of information we ask for, then you'll be contacted to finish the application process from our Social Security office. Or you can directly call the phone number posted there and set up an appointment at your local Social Security office. I know that we're now scheduling more than a month out. So as soon as you think you're ready to apply, you need to do so. Next slide. After you've applied online or you go into the field office, your local Social Security office, one of our staff will explain to you about program requirements, our definition of disability, and the disability process. The claims rep, which is what we call our staff member, will also require we'll get the required applications and form from you so that we can process your claim. Next. From now on out, there won't be any paper at all. Your case will be forwarded to a local disability determination services office. Excuse me. This is usually located in the state where you live. And they will develop, and that means they'll write all your sources and get information in. They will document your claim to the standards we require for Huntington's disease, and they will propose a decision. Next step. And this is, again, a follow-up on the disability determination services. They are, in fact, state agencies but they're not independent. They follow all of our rules, and we fund them 100%. Next. The local DDSs gets evidence in a lot of ways. Mail, and if it comes in mail, we immediately convert it to an electronic picture. They can get it by telephone. We take records and write it up. By fax, by something we call the Electronic Records Express. Physicians can hook into our computer and push information to us. And the newest way is with health information technology, where our computer literally talks to their computer at the medical site and gets evidence in before we even see the claim. When we're working up a case, we always gather medical records. If needed, we gather vocational information, and we don't need that if we are proposing a listing, that you meet the listing. We always, and this is especially important in Huntington's disease, try to obtain an activities of daily living report. Let me tell you, one of the best things that you can do to assist an applicant, or if you're an applicant yourself, is keep a diary of what you can and cannot do during the day. You don't need it to be the worst days. You don't need it to be the best days, but just say what you do. What we're looking for are things like, are you taking care of the kids? Are you cooking for yourself? Are you paying the bills yourself? This is information that will help strengthen your file. This diary can also be corroborated, if you wish, by information from a spouse, a family member, a friend. Next slide. The disability examiner, again in the DDS, reviews the claim for the disability reports, medical releases, vocational evidence if needed. Next slide. They also ensure that there's sufficient medical evidence to make the determination. Verifies that we have all the required medical documentation in file. If needed, requests additional evidence, resolves conflicts within the evidence, and, if needed, schedules a consultative examination with one or more medical specialists at our expense. The medical consultant and the DE, this is an important concept. The medical consultant works with the disability examiner in a partnership to make these decisions. The medical consultant or psychological consultant reviews all the medical evidence and assists the examiner in case analysis and completion of physical or mental residual functional capacity evaluations. The vast majority of cases are adjudicated as a partnership with DEs and MCs. However, CAL conditions, if the evidence is in and is very clear, can be made by the disability examiner alone. Okay, in terms of the disability determination, if it's a favorable decision, we automatically notify the field office that the decision is complete. However, before the next action is taken, a sample of cases is reviewed by our quality assurance review, and the sample for allowed cases is 50%, so it's a very large sample. If the determination is a denial or unfavorable, we alert the field office and we mail a letter to you, and of course you can appeal the decision. And what I want to emphasize is that of all people awarded benefits, over 70% are awarded their benefits at the DDS level, the initial reconsideration level. The next are just pieces of data in the last 4 years. You can see that we do about 3 million cases a year, initial and recon. So you'll see that the HD is a fairly rare condition. Nonetheless, it's terribly important. In terms of the initial, the allowance rate for HD is about 72%. The allowance rate for all conditions combined is about 33%. At the reconsideration level, you'll see that the allowance rate for Huntington's disease is about 37%, and for all conditions aggregated, it's about 11%. And at the hearings level, you'll see that the allowance rate is 77%. Where for all conditions the allowance rate is about, it's about 55% now at the hearings level. So you can see that Huntington's disease cases get allowed with a greater frequency. Now, why might you get denied? Well, the most common reason are for technical reasons. For example, if you haven't worked in the last 10 years, you might not be insured, or your insurance might end a number of years before. To be granted benefits, we've got to prove that you were disabled on or before that date last insured, for example. The average age of all claimants is about 44, which is certainly not a surprise in the Huntington's community. And of all allowances, most were made as a listing allowance to 11.17, and that's the neurodegenerative neurological disorders. In July of last year, we have created a separate diagnosis impairment code so that we can track Huntington's disease claims data more accurately. This is going to help us make sure that claims are done correctly. Reconsideration. Again, if you are denied on the initial level, you can appeal. In some states, in some states, we have a few states that don't have an appeals process, and it goes directly to the hearing. But in the 40 states that have a reconsideration, the case is sent to individuals who were not involved in any way in the initial determination. We make sure, again, that we have all the evidence, get more evidence if we need it, we make a determination. If the claim is denied again at the reconsideration level, you can appeal and go before, next slide, go before an administrative law judge. You'll have 60 days to appeal, and you'll have 60 days from a hearings level denial to request AC review. What's happening at the hearings level is that you'll be seen probably for the first time, except at your application, by someone in what we call the largest administrative judicial system in the world. While there are 15,000 DDS employees and about 85,000 SSA employees, if you count the DDSs, there are almost 1,300 federal judges, and they're all over the country and make about 500,000 decisions each year. In terms of the process, the most important thing for you is to timely appeal. Don't let it wait. The best way to get benefits is to continue, if you believe you're eligible, is to continue to appeal. You'll file a hearings request. Then the ALJ hearings office will do pre-hearing development, assign to the judge, hold a hearing, make any additional development, and adjudicate the case. This is not adversarial. You can appear before a judge in person or by way of video conference. Your testimony is taken under oath, and an exact recording is made by a hearing reporter. You can testify, you can bring witnesses. They may bring a medical expert or a vocational expert. When I say they, it's the judge. If it's a child's case, of course, the child's parent or guardian can appear, and if appropriate, the child. Now, let's talk specifically, and I'm almost near the end here, let's talk specifically about Huntington's disease. And the first bit is establishing a medically determinable impairment. We have to do two things in the disability program. One, we have to prove the existence of a disease that can be disabling, and two, we have to prove that the symptoms of the disease limit your ability to work. So it's pretty easy to establish Huntington's disease. First of all, we certainly can accept genetic testing, which shows the typical CAG repeats. However, it's not required to get genetic testing. What we also get is clinical findings, a history, a family history, and then clinical symptoms to demonstrate that the applicant has Huntington's disease. That establishes the MDI, but it's not enough to qualify for disability benefits. The second thing we need to do is evaluate the level of impairments, both physical and mental. Physically, of course, we're looking at gait, ability to walk and stand and station, or gross and fine motor movements. And the typical career movements are obviously there. I want to thank Jane and the entire HDSA organization for emphasizing, however, that those sometimes can be a later finding, that the emotional and behavioral issues come first, especially in children, and the cognitive issues with memory loss or ability to do calculations come often before the career movements. And they can be as disabling and can certainly point us towards an allowance. Next slide. Again, you can click on those listings, go to our listings in one of the earlier web links, and go to 1117, which is degenerative diseases, special senses for loss of speech, or the mental listings for organic mental disorders, and, by the way, some of the others that will help document the emotional issues surrounding HD. I do want to state that we just presented our internal proposal to revise the neurological body system to my bosses yesterday, and we hope within a fairly short number of months to be able to send it out for Office of Management and Budget review, and thence out to the whole world to let the communities comment on what we're proposing in our rulemaking process. So very soon, HDSA and you will be able to comment on what you like and don't like about our proposals to evaluate Huntington's disease. If you don't meet the listing or the applicant does not meet the listing, we do look at all the factors of the ability to do past or other work, and that includes such basic things as standing, lifting, carrying, understanding, getting along with people, and the ability to sustain work activities on a regular basis for 8 hours a day, 40 days a week. Here's a tip for you. The first tip I already told you about, but I'm going to say it again. Knowing what your daily activities, what you can or cannot do because of your impairment, how Huntington's disease limits you is extremely important. Secondly, it's always helpful to have a statement from your treating physician, your neurologist, if that's who's treating you, about what you can do, your mental functioning and how much you can do in a day, how much you can do in a week. And if you can tie that to the clinical findings or your clinical observations, it really helps. Now, many, many HD patients are seen at centers of excellence, and we're working with them, of course, to make sure that they understand these rules. So this is not something that you'll always need to push forward, especially as we get out to everyone, but they're good hints to know. Go ahead. And again, anyone who's familiar with the applicant can give us evidence, can give us information. These are forms, and they're perfectly acceptable to use, the function report and the third-party function report. But that said, it's just as valuable to have a narrative describing how your day is limited by your condition. Now we're at the end, and I look forward to opening it up for questions. We've got a good half hour, and I will try to answer any questions. If we run out of questions, please note that we are glad to take follow-up questions. If you'll send them in to Jane at the HDSA, she will forward them on to us. Jane, let me open it up to questions.
Thank you, Art. So just as a reminder to ask a question, you just type it in on your screen and you hit send. Art, I believe that there is a question that is coming to you right now.
I'm not sure how to see it. We're still seeing our slides, so I think you probably have to get out of this. Or Jane, could you just read the question for me?
Yes, I can read the question as soon as I get it. Give me just a second, please.
Sure.
Okay, so let me just give me just one moment, please.
Okay, see if you can get this down.
I'm just undocking it.
Okay.
Okay, so the first question is specific about CAL. Can you tell us a little bit more about the average time frame for review under CAL versus a standard disability review?
Yeah, and I'm so glad that I've got some smart people with me today. And by the way, around the table is Terry Dotson and Deborah Dennis, Terry leads our CAL initiative process and outreach, and Debbie is our expert on CAL. And I'm going to ask you that question in about 2 shakes, Debbie. I also have Amanda Wolf, who's the Deputy Director of our listings team, our medical policy team. And I also have Janet Truey, who I dare to say, I should say this, yeah, she's an attorney who helps me stay out of trouble, and she has the hardest job in America. So Deborah, how long does it take to do a CAL case?
CAL cases take a matter of days or weeks as opposed to months for cases that do not go through fast tracking. It is important to note that that days to weeks is calculated once the DDS actually receives the case. For example, a person may apply at a field office and they're working with the field office staff to get information. So the clock does not start ticking until the field office actually sends the case to the DDS.
The average time for an initial case for all cases is about 100 to 110 days. So it's significantly shorter if it's a CAL condition.
Wow, yes, that really, really is. So another question, if a person is receiving state disability for the first 12 months of their disability, when should they apply for Social Security disability?
They're not the same program. I would say apply immediately. Again, as soon as you believe that you're not going to be able to work for at least a year, apply. Now, there are only 5 states with a temporary disability program, and those are Rhode Island, New York, New Jersey, California, and Hawaii. And they have some different rules and some different time periods. For example, New Jersey, it's only a 6-month program. But I would say do not delay. We want to get all potential awardees on the program as soon as possible.
Great. Thank you so much. So another question is if the medical documentation provided in the initial application did not include all the testing that was done, would a reconsideration be more likely to be accepted if the case was initially denied once that follow-up information is provided?
Yeah. If I can leave you with one thing, it's that Social Security for Huntington's disease needs 2 things. Proof that you have Huntington's disease, you or the applicant have Huntington's disease, and that's pretty straightforward. If you have a family history and the clinical findings and medical history, we certainly accept that, or the genetic testing. But the second piece is terribly important, and that is how it limits you. And again, this is the chorea movements and the ability to use your hands and feet, the intrusiveness of the spasms, but also the emotional and cognitive limitations. Of course, we've seen some HD cases where people have lost the ability to control their anger, people have lost their ability to wisely manage funds. In some cases, people have lost the ability to act appropriately in terms of their sexual or other behaviors. We've also seen Huntington's disease cases where both the memory and the ability to do things like pay the bills is limited. Those are all important findings that can help us make an allowance determination.
Great. So I have another somewhat nuanced question. Can you talk about the difference between the description that appears next to CAL that I believe is called the impairment summary and the disability listing? How are they different? How are they the same? How are they related?
That impairment summary is a guide for our internal medical consultants and disability examiners on how to look at Huntington's disease so that we can prove disability. And the reason we do that is, again, if we're doing 3 million cases a year and you see some of our numbers, that with Huntington's disease we probably have only about 2,500 in a year, we don't want folks to miss the impact of Huntington's disease. And that's one of the reasons we did the CAL proposal. when you don't see a case all the time, you can make mistakes. It hasn't happened so much with Huntington's disease, but I will give you another one. There's a type of lymphoma, it's called MCL, that is fairly rare in terms of the cancers and lymphomas that we get, but it's different. Lots of lymphomas react appropriately to meds, and when I say that, that means you actually can get better for a very long time. But this certain particular one leads inevitably to a relapse and death. We were finding that after we Septical, many folks were being denied because our adjudicators were confusing it with the other lymphomas. So what we do with this, this summary is guide the adjudicators on how to develop the case and how to evaluate the case. In the bottom of that sheet, the second page, if it's printed out, you'll see how it ties into the listings and the medical equals. So I hope that helps.
Great. Thank you so much, Art. So a next question, and the first is a thank you. The person, and I think that this person speaks for a lot of people, really thanks you for doing your homework about HD and about sort of the in-depth knowledge that you've presented. And the question is, since many folks with HD do not get tested, or even understand that they have HD, which is known as unawareness or anosognosia, how does the Social Security Administration determine how far back to go back with the onset date?
The onset is the latest of two periods. One, where you're not working at substantial gainful activity, and two, where your impairment is so severe that it prohibits all work. We don't, when you say testing, we certainly don't require genetic testing. We understand that there's a significant population who don't get the testing. To be honest, in terms of their life, what will it do to help them? And so that's why we just as readily accept what a doctor says in terms of their clinical history and their examination and their family history. Of course, there's a very small number of cases that present without a strong family history of HD. It's a very small number, either through adoption or those rare new HD patients. But nonetheless, a doctor certainly can do an examination and come back and state, you know what, I think we're looking at HD, and then they keep evaluating them because over time, as we all know, the symptoms only get worse. But we grant benefits. We set the allowance date at the latest of those two things. When the evidence shows that you are so impaired that you can't work, and the listing is one way to do it, and you're not working.
Thanks, Art. So another question. You said that people can apply for Social Security disability when they've stopped working. Yeah. What if they're still working but on very limited hours? Can they still apply then, and how does that work?
Yeah, this gets very complicated. Okay, so your individual case might need to be looked at. The best way to do that is by talking to someone in Social Security. But I can give you a couple of examples. One, the substantial gainful activity level is $1,040 this year. If you are working but making less than that, we don't consider that work. That's one way to think about it. But there are other things that can happen too, and that is, for example, you're working in your parents' restaurant. You're helping out as best you can. But to be honest, when you look at the work done, it's really a subsidy. So your parents are being nice to you, or your employer, if they're not your parents, are being nice to you and keeping you on and paying you a salary, but it's really not for the work you're doing. That also can be thrown out, and you can be evaluated for disability as if you were not working. But there are a lot of exceptions. Everything I say today, there's probably 10 exceptions for, and that just drives everybody, including us, crazy. But on your particular case, I would strongly suggest that perhaps you send information into Jane Cogan, and we can look at it and get some feedback to you, or just go down to your local Social Security office or call that 800 number.
Thank you, Art. So another question that somebody has, and I think that this is likely a little related. This is somebody whose husband has been on short-term disability for about 9 months, and they're going to need to extend that time. Can they start the disability process now, or do they have to wait until he's no longer considered employed?
No, if he's on disability, and I'll give you another example. We'll use the military example. If someone has been wounded in war, they're in fact still getting paid, even though they're not doing any work. We don't count that as substantial gainful activity. SGA is working for the money, okay? So if this individual is on a temporary disability for 9 months, that suggests that they're not able to work, and they should look into applying for benefits.
Thank you, Art. So based on another question I have, and it's again a statement and a question, so this is somebody who comes from several generations in HD, which, as you know, is typical. Yeah. Yep. And the individual with HD, in most cases, does gradually lose the ability to make decisions on, they lose their motor skills, emotional stability, and generally their ability to function in the workforce. And with that comes the ability, loses the ability to get rehired. So this individual's observation, and they want you to comment on it, is that the formal diagnosis for HD and the fact that it is currently incurable and gets worse should automatically qualify somebody for Social Security, and that they want to sort of comment on how the Social Security Administration is trying to simplify the process.
Well, we simplify the process by making sure that our listings are up to date so that we know what our current medical thought is regarding HD. Of course, there are no treatments now, no effective treatments or no curative treatments by any stretch of the imagination, but we are also aware of the hard work that's going into research, and that with the genetic findings, maybe in the next generation or the one after, we're going to be able to correct the CAL repeats. So we've got hope in that regard. To answer the question, why can't I just accept the diagnosis of HD because you know what the final outcome is? And the reason is that while that's absolutely true, the Social Security definition of disability is very strict, and it does not presume an inability to work in the future. It presumes an inability to work now. We certainly have no problem allowing benefits, and as some of those numbers suggested, we allow it a much greater frequency than in the regular program, no matter what the conditions are. But that said, this is no different. I'll use, by analogy, another story. We've gotten an applicant, for example, with an aneurysm in the brain, and they're not impaired. But by golly, they're going to be, and it's probably going to leave them with long-term disability or death. But until something were to happen, we can't award benefits. Now, we can consider that they should not work in places where they might get head trauma, for example. But again, we by law are an extremely strict program. Oh, let me make another comment. You, Jane, and through you, the listeners, thank us for being prepared and knowing about Huntington's disease. Well, I need to turn that thanks back. I want everyone on the webinar to know that Jane and the HDSA team from New York and around the country have been very, very helpful in making sure that we, in Social Security, understand HD and the unique nature of Huntington's disease in the program. So really the things have to be shared.
Oh, thanks, Art. So more questions. So if somebody's in a clinical trial or an observational study, should they add that to their application, is the first question. And the follow-up question is, if yes, should they also be sending any feedback about themselves as far as progress notes as part of their evidence?
Yes and yes. The more evidence that you can submit, the better. We need a picture. We need a picture of you. And the best way to get that picture is through progress notes, is through evidence from your doctors and hospitals and clinics. Anything that might help us understand how you're doing is what we need.
Great. Thank you, Art. So here's another question. Many people with HD don't recognize their own symptoms. In that case, would it be helpful for them to appoint a representative, or how can a caregiver help, is the first question. And the follow-up is whether having a representative can ever serve to damage their case.
No, having a representative won't damage your case. I would say that it can certainly be done if the individual gives permission for us to work with, talk to, deal with a caregiver or family member, then we can. So this is really up to the applicant unless there's a power of attorney granted to someone else. But if John Jones says, please with this, please work with my mom, I'm confused, we will absolutely do that and make sure that the mom then gets all of our correspondence or all of our phone calls, and sometimes it can be a lot. In terms of representatives, often people think about a lawyer, and the program is not designed so that you need a lawyer, but you can, of course, get either a lawyer or non-lawyer representative at any time. The problem with that is, of course, is that if awarded benefits, you end up having to pay out of your benefits. And I'd love it if we could allow you and you get all the benefits, but that's just me.
Well, thanks, Art. And it sounds like what you're saying is that in order to get help with some of the unawareness, a caregiver can be allowed to help and give a corroborative statement. So it doesn't necessarily have to be a paid representative.
That's correct.
But it can be.
Yeah. Probably the best information would come from family and friends and relatives. Yeah.
Great, and actually this is a related question from a caregiver of somebody with HD. Can you talk generally in specific terms about some best practices for caregivers for getting disability for someone if they're in complete denial about having the disease and symptoms despite having a genetic test? So they're going to make different statements.
Yeah, you have really set up a very difficult situation there. We have seen some cases where the applicant cannot believe that they're losing their ability to function. So a couple of things can happen. One is they can refuse to apply for disability. They can refuse to let the family member or caregiver speak for them. And we are really stuck if that's the case. As a matter of fact, you might be forced to go the more legal route and become named as a legal guardian, which is complicated in every state, but nonetheless, that may be what you're forced to do. We also realize that we can get inconsistent statements, that we can get information from the applicant that represents, belle indifference, where I'm fine, I'm doing good, I can do everything I normally do. But the caregiver knows well that that's not the case. The best thing a caregiver can do is kind of keep a record over a short period of time that documents the losses in the ability to deal emotionally and cognitively and even physically. That gives us information about falls or slips or cuts while trying to prepare dinner, for example. And I would not be shy. I'd say you may get something from, John that says he's doing fine. He is not. He simply cannot at this point, in his illness, recognize what's going on. Does that help?
I think that's a really great start. If there's follow-up questions, definitely send them the way. But the takeaway from this is just document.
Absolutely. Absolutely. And so much can be done by the applicant and the caregivers and the teams that work with you in the HD Centers of Excellence.
So here's a, I think, somewhat easier for you technical question. Can you just go over the dollar amount that a person can earn every month when they apply for disability?
The SGA level changes every year. This year, last year it was $1,010. This year it's $1,040 a month. It's not very much, but nonetheless, that's the level that we consider to be substantial gainful activity. And again, there are exceptions. There are things that we can discount, and that is done on a case-by-case basis.
So a more technical question. So if somebody's daughter is currently working, but she is showing cognitive, some cognitive limitations that are limiting her ability to work, and she is having gait impairments.
Yeah.
The doctor told her, the doctor told the person to apply for SSI to get the process going, but the Disability Determination Services told the person that if the daughter is working, to not even waste your time applying, since she's automatically going to be denied. So what is your advice to this person on how they should proceed?
You got to go a little deeper into it. If she's working, we do want to know how much, and we also need to know some of the things I mentioned earlier in terms of there's a chance perhaps that she's working and her work is being subsidized by her employer, that they know in fact that she really can't do the work, but they're keeping her on because she's been a good employee. These are all factors that can be considered and might rule out that SGA is in fact happening. So it depends on the case. One thing I think you could approach is try to get the daughter's employer to write a very candid letter about the problems that she is having, and clearly state that, you know, we're keeping her on because she's been a good employee, but she's really not earning her keep. That's a way to get that thing moving forward. As soon as anybody tells you that there's any topic on Social Security disability that's easy or straightforward, they're not telling you the truth. It's very complicated and it's exception driven.
Oh, that does definitely sound complicated, and something that you've said also, that if you do get a question that's complicated and nuanced, please send me an email. This is Jane Kogan to jkogan@hdsa.org, and I will try to get those questions answered by the Social Security Administration that are a little bit more specific to your case and less sort of general, because as Art said, their specifics are basically specifics are everything. Yep. It sounds like.
Jane has us on speed dial. She's a good advocate for you guys.
Oh, thanks, Art. And you, the Social Security Administration, as Art said, Art has an entire team behind him. So if you do have a nuanced question, they can get it answered.
Yes, try.
So another question. Can you talk about, once somebody's approved for SSDI or SSI, can you talk about the periodic reviews, especially for a condition like HD, which is progressive and is going to just inevitably get worse?
You will get information that says we will re-examine your case. However, HD is one of those conditions that we consider permanent, and the diary is set for 7 years, and we might even put it off past that. There is no chance that you will get, that you will improve. That's certainly what we know about Huntington's disease. So I think the least of your worries would be a periodic review. There is no realistic chance, unless a mistake was made, that you will have benefits taken away from you, even if we do review your file.
Thanks, Art. So another question, and after this, we have about 4 minutes left. I'm going to have time for one more after this. So can you talk about are the benefits awarded under Social Security? Can you talk about basically benefit amounts? I know that you said that Social Security disability insurance, you get a lot more than SSI, but what about the benefits under Social Security disability insurance and retirement benefits? How do those compare?
Yeah. Well, you get your retirement, your full retirement age benefits after you've completed your work life, most of us at age 66. And that number changes based on your birthday. What you get in terms of disability is what you would have gotten at your retirement age, 66. So while it's not a dramatic amount of money, it's limited by how much you've made. It does average about $1,200 a month, which means that there are some that are lower and some that are higher. And after 2 years of being on benefits, you get your Medicare, which is a substantial amount of money that you save by having health insurance.
So, thank you. That does clarify that. And if anyone has any questions, as I said, please do continue to send them on. But this is our last question, which is perfect. Art and everyone else in the room, thank you so much for your presentation for today and for all of the work that you do to try to help streamline disability reviews for people with HD.
That wasn't a question.
No, that was a thank you and a kudos.
Well, thank you very much. Again, we understand we are not only sympathetic and empathetic, we understand the difficulty that HD brings to the patient and the family and the community, and we will do everything in our power to make this process as easy as it can be.
Thank you.
And HDSA is a great advocate for you, so stick with them.
Thank you, Art. And to everybody who's still listening, thank you. And please be sure to give us feedback on what you've heard, and tell us what else you would like to hear as far as disability, so that we can try to continue to educate folks and tell you what you want to hear. Thanks you, everyone.
Thanks for coming, guys. I appreciate it. I better run to the next meeting.